I'm going to take you step by step through my reasoning that I'm building up slowly but certainly, and here and there I will include also some theory to make it hopefully more understandable. Emphasis being on the fact that what I'm presenting here is, of course, my interpretation of what I see happening in that particular line of cases. As it's typical for law, of course, you've got the text, the text of a judgment, and the interpretation of that text. So this is also my interpretation, and I basically am inviting you to, go in debate and maybe have a different opinion or ask me questions about why I'm developing the interpretation the way I do. So I'm definitely inviting questions, critical questions, especially at the end, which doesn't mean that if there is something that you don't really fully understand, you should feel free to ask me. In the Netherlands, we teach very interactive, very openly. I might even ask you some questions as we go along, so just to see how things are landing. So I hope this is going to be we're here in an informal setting, and I would like to keep it that way. So it's not just me sending information to you, but it's more something that also has scope for interaction. Okay, so be that as it may, as you can see on the title of this slide, I'm going to talk to you about the integration reasoning at the European Court of Human Rights, challenging the boundaries of citizenship. Now, the European Court of Human Rights is often a source of inspiration for other international, regional, and also national courts. And so it merits understanding that we look at that court. At the same time, I need to acknowledge that the court may be the highest, the most respected international human rights court, but it doesn't mean that its jurisprudence is always free from criticism. There are several lines, several judgments that elicit academic criticism. More particularly or specifically when it concerns claims put forward by ethnic, religious, and linguistic minorities. Traditionally, the lack of a minority-specific provision in the European Convention on Human Rights translated in a rather restrictive interpretation by the court of these rights. Now, in the meantime, as it was also highlighted on the slide, the jurisprudence of the court shows important shifts. It's willing to open up to substantive or real equality, going beyond mere formal mathematical equality. You can see that happening at least at the level of principle. Similarly, the court has acknowledged that in terms of the European Convention on Human Rights, there is also a right to be respected in a traditional minority way of life. And so promising principles once again. Nevertheless, if you look at the overall jurisprudence of the court in relation to minorities, it's still a rather mixed picture that you see. And that means that these promising principles that I just highlighted, they do not necessarily translate into an optimal protection of the fundamental rights concerns. And that basically has to do with the fact that the court tends to grant states a broad, what it calls margin of appreciation, a broad discretion, in relation to controversial questions, such as questions that concern the accommodation of ethnic, religious, and linguistic minorities. I will come back to that as we go along. Now, obviously, I can't cover this whole jurisprudence here. You wouldn't want that, because I would be busy for a week, and that's not the idea. Here, I will zoom in on a particular worrying development in the case law, which is visible in several recent cases that have been brought to the court by religious minorities with a migrant background. And what we see happening in these cases, what I will explain, is that in these cases the court accepts actually quite far-reaching limitations on the fundamental rights of these religious minorities with a migrant background in the name of integration. And so that states are allowed to disrespect the wish of these minorities to be respected in their religiously inspired way of life. Furthermore, the court actually glosses over a context of Islamophobia and related stereotypes, and then fails to identify instances of discrimination on the basis of religion. So these are the two pillars that I am developing. Basically, my central argument is that in the two cases that I'm going to zoom into, that what you see happening is that the court basically drifts away from the counter-majoritarian core of fundamental rights, and in the process allows states to push religious minorities with a migrant background out of the public space, out of public schools, in the name of social integration. And at the same time, it disregards the foundational value of the right to equal treatment within the human rights paradigm, ultimately resulting in a move away from an equal, inclusive citizenship. So, how am I going to develop my argument? So first I'm going to give you a brief overview of these two cases. Brief in the sense of I'm going to keep it set. I'm not going to give too much analysis. It's just telling you what are the cases about, what are the claims put forward, how does the court react to it. I try to keep it set, and so not too much analysis yet. Subsequently, we're going to look at, so integration, where does it come from, how can we reflect on that? Similarly, this concept of citizenship. These concepts that I'm using in the title, I'm going to explain them a little bit, discuss them, to then subsequently return to these two cases and have a close analysis of them in light of, or from two particular angles that are related to the discussion in terms of integration and citizenship. So to then conclude to what extent you actually see the court challenging the boundaries of citizenship in these two cases, ending with some conclusions, some recommendations towards the court. Now, here I want to also emphasize that, which is also very important, the court doesn't proclaim these things out of nowhere. It doesn't proclaim the interpretations of the convention just because it feels like doing that. It does that in relation to particular cases that come before it, and governments justifying particular limitations of fundamental rights in particular terms. And so it's often in response to particular actions by governments and justifications put forward by these governments that the court is developing its arguments. So I want to nuance my focus on the European Court in that respect, that it's not just the court doing bad things, but that it's in response to governments' actions and justifications. Nevertheless, it's important that when the court gets such cases, that it reflects on what's happening and that it responds appropriately. And there I've got a critical assessment. And so why do you think it's especially important to focus on what the European Court of Human Rights is saying? So I'm also going to ask you some questions. So try to reflect a little bit. Why is this particularly important? What this European Court of Human Rights is saying? Now, obviously, when the court has the power to pronounce legally binding judgments, and it is the official supervisor of the European Convention, so when the court makes a judgment on a particular matter, it sends a signal, it's a symbolic signal about what are the boundaries of human rights, the way it's perceived by the court. And this does send a signal to the other states that are similarly confronted with complex questions relating to minorities. And so these states think, if this is okay, then I can do it too. And that's exactly what you see happening after the first case, the SAS versus France case, the first one I'm going to discuss. You saw similar cases coming up in Belgium and cases coming up to the European Court, and it's exactly the same reasoning put forward by the Belgian government as the French government, and the court says exactly the same thing. So you've got this oil stain that is spreading. So this is important to keep in mind that, what happens at the level of this one judgment of the European Court, it's never just one judgment. It always has potential to spread into something more widely. And so that's why it's particularly important to have a look at that. So let's start with having a brief discussion of these two cases. So first of all, SAS versus France. I don't know, who of you has heard of that? Because it actually got quite some publicity in Europe, in my part of Europe in any event. Because it is actually the first case that the court had before it, where it was confronted with a legislation that amounted to, and was also dubbed, a burqa ban. And so this very controversial question in several European countries. This was the first time the court was ever confronted with this question. So it got lots of media attention. The Osmanoglu case has received way less attention, but I'm going to show you that it has quite some parallels with SAS. So, and that's why I'm going to discuss them in that order. So SAS, what is this about? It concerns the French law that prohibits the wearing of clothes that conceal the face. It doesn't only prohibit it, it also criminalizes it. And basically, the complaint was brought by a French woman, a French Muslima, who wants to wear this full face veil when entering the public, when being in the public space. And she claims, well, this law and this prohibition, this criminalization, this basically amounts to a violation of my freedom to manifest my religion, and also it amounts to an indirect discrimination on religious grounds, because it may be a neutral rule, but it disproportionately affects women who want to cover their face for religious reasons without objective justification. So that was the indirect discrimination frame. So basically, what you see happening and what is also acknowledged by the court is, yes, there is a problem in relation to these two rights. There is an interference with the freedom to manifest your religion, and indeed there is this disproportionate impact on women who want to wear the veil for religious reasons. So the court acknowledges that there are problems with two fundamental rights. And then we get into this question, yes, fundamental rights, all good and well, but most fundamental rights are not absolute, which means that states are allowed to limit the enjoyment of these rights under particular conditions. So what we then need to do is, and the next step when there's an interference, okay, so what are the justifications put forward by the government? Is that in compliance with the requirements that should be met to have what is called a legitimate limitation to the fundamental rights and no violation? So basically, both the freedom of religion and the prohibition of discrimination have two central requirements that need to be met. On the one hand, there needs to be a legitimate aim for this interference or for this differential treatment, and there needs to be a relationship of proportionality between, on the one hand, the legitimate limitation and that legitimate aim that it pursues. So these are the two requirements that need to be met. And then I want to make a specific point, which is going to be also a red thread throughout my discussion, the question that, the position of the right to equal treatment or the prohibition of discrimination. And so on the one hand, you can say, well, this equality principle is actually is embedded in the notion of fundamental rights. Well, how do you describe fundamental rights? These are rights that you have simply because you're a human being, irrespective of A, X, Y, and Z, irrespective of any other characteristics. So this whole idea of equal treatment is, as I said, embedded in the notion of fundamental rights. And so to some extent it seems very closely related. At the same time, and I think this is a very important point, the prohibition of discrimination is still a distinctive right. It adds a distinctive dimension, and I'm very much going to analyze it as such, so separately from, distinctively from the freedom of religion. Now let's zoom in what happens in relation to the freedom of religion complaint. So according to the court, there is a legitimate aim and there is this proportional relationship between the legitimate aim and the limitation. Now, what was the legitimate aim that was invoked by France? France invoked one of the legitimate aims in Article 9 being the protection of the rights and freedoms of others. And then it had three subcomponents thereof. On the one hand, it invoked gender equality, and there the court said, no, we don't buy that, because this is a practice which is actually defended by the women themselves while they want to exercise or manifest their religion. So the court didn't accept that. The second point was, yes, human dignity. And the court said, no, we don't accept that as a legitimate aim, because respect for human dignity, basically this concerns a particular cultural practice, an expression of a cultural identity, and this contributes to pluralism which is inherent in democracy. So you cannot possibly proclaim that limiting that would be furthering human dignity. So the court also says no to that. Okay. Then we come to the third one. The third argument that France put forward is, well, this limitation is necessary in view of the minimum requirements of life in French society or living together. And more particularly, and here I'm going to quote, the court is able to accept that the barrier raised against others by a veil concealing the face is perceived by the respondent state as breaching the rights of others to live in a space of socialization which makes living together easier. So the court accepts that as a legitimate aim. Now, obviously, the word integration hasn't fallen yet, that the court doesn't use the word integration, but I hope that you see that living together arguments and these arguments of requirements of life in French society, it dovetails quite closely with the concept of integration. So this is why it's been put in this as an example of integration reasoning. Now, importantly, actually, at the level of the discussion of legitimate aim, the court already acknowledges several problematic features here. So yes, it accepts it as a legitimate aim, this living together argument, but it says, well, we do need to acknowledge that it's quite a flexible notion, living together, so that could be abused, and we need to carefully examine that. That's point one. Point two, the court notes with deep concern that there was proof put forward by third parties that at the moment that this law was adopted in the General Assembly in France, that there was also a lot of Islamophobia remarks being made. So the law may be neutral, but it was clearly placed in this Islamophobic context, so it was targeting Muslims, or that was at least visible in these negotiations. So the court notes that with deep concern. And it even adds explicitly that when a government chooses to adopt a law in such a context, such an Islamophobic context, it basically runs the risk of strengthening stereotypes against a particular group. So that, if I don't know what you feel, but if you read that, you would think, the court is basically announcing what? Is it announcing that it's going to scrutinize lightly, or is it announcing that it is scrutinizing strictly? What do you think? If you hear it like that, and the concern, and there's stereotypes and risks for that, arguably, the vibe that is created is, we need to scrutinize seriously, strictly. We need to be, very careful with this. Interestingly, when we turn to the proportionality review, to the second requirement, the proportionality requirement, the court actually does not adopt strict scrutiny, no, because it gives a broad margin of appreciation, a broad discretion to the French government, because there would not be European consensus on this particular matter of, whether or not you can prohibit the wearing of the veil, and because it would be a choice of society. And this is, of course, when you give a broad margin to the state, that means that you, as a court, step back and that you don't scrutinize closely. So the broad margin is saying, okay, we're not going to scrutinize closely, and what you see happening is then, of course, violation or no violation. When you scrutinize very lightly, what do you think? Violation, no violation? No violation, no violation. When it's a light scrutiny, virtually any justification will go. And so the court concludes that there is no violation. And then, when we turn to the complaint about indirect, so there was a lot of paragraphs dedicated to the question of the freedom to manifest your religion. And then there's this one paragraph, very small, concerning the complaint about indirect discrimination. Basically, the court says, yeah, indeed, this law has this disproportionate negative impact, which I already said, but for the reasons just given in relation to the freedom of religion, there is a reasonable and objective justification for the disproportionate impact, so there is no indirect discrimination. So what you see happening is that basically without any additional argument or any discrimination-specific argument, the court just says, well, no. For the same reasons as already given, there's also no discrimination happening here. So that deals with that case. So no violation of the freedom to manifest your religion, no prohibited discrimination. Okay, let's go to the, oops, there's something doing wrong here. Okay. Yes, Osmanoglu Kosabas versus Switzerland. This doesn't concern a law that criminalizes particular manifestations of the freedom of religion. It does concern parents that got a substantial fine because they didn't want their female children to participate in mixed swimming in a particular public school because this would be contrary to their religious convictions. So basically, this mixed swimming was part of the mandatory curriculum, and the parents asked an exemption from that mixed swimming class, and they didn't get the exemption from the school, so they kept their children at home. They didn't, well, at least for this school, they didn't let them participate in these mixed swimming classes, and they got this huge fine they had to pay. And then they eventually, after having tried all the national courts, they end up with the European Court of Human Rights and claim this is a violation of our freedom of religion. Interestingly, even though they don't complain explicitly in terms of, there's a discrimination going on, they do hint at a discriminatory application of that exemption scheme, because they say, well, when this claim for an exemption comes from Orthodox Jews or Orthodox Christians, they get it, but we don't. So there is, even in that case, even though they don't make a discrimination complaint separately, they also hint at a discriminatory application of that rule. So what you see happening here, the court, again, indeed, there is a limitation of the freedom to manifest your religion, but again, the court says this limitation is justified because there is a legitimate aim and there is this proportionate relationship. Let's have a closer look at how this happens. And what you notice here actually is that here, in this case, there's explicit integration reasoning that pops in. So here, the legitimate aim invoked by the government is also the rights and freedom, the protection of the rights and freedoms of others, more particularly filled in as, so basically the obligation to participate in mixed swimming would be, the legitimate aim thereof would be optimizing the social integration of foreign children with a different cultural or religious background, and also to avoid them from being exposed to social exclusion. So that is the legitimate aim put forward by the government. Now, interestingly, the parents, the applicants, they contest the way the government put forward its vision of integration. And there's actually quite an extensive argumentation about what does it mean, integration, and not going back and forth between these two. And so basically they try to refute the claim of the government that participation in these mixed swimming classes would be necessary for the integration of their kids. But I'll return to that later. So what you already see here is full-on reasoning on the meaning and implications of integration. So, but okay, legitimate aim in terms of integration goals of the state, accepted. And the proportionality, also here, the court gives a broad margin of appreciation because it concerns a matter that is closely related to the relations between church and state, and there is no European consensus in this respect, and it concerns public education. Let me return a little bit to what I said, because I haven't fully explained how these, or properly explained how the parents what the parents actually contest. So the parents, interestingly, they say, yes, social integration is very important. We totally agree with that. So they don't contest that as a goal, but they say, you know, we and my kids, the kids are perfectly integrated in Swiss society. We speak the language, we go to the schools, and we work here, and we're in very many ways participating in the local, in our local community, etc., etc. So basically, these parents said, well, the integration of our children doesn't depend on whether or not once every 2 weeks they participate in mixed swimming. So they really play into this integration lingo, but they just put forward a different interpretation thereof. Okay, so as I already said, the proportionality, again, broad margin. So there is no violation established of the freedom of religion. And so the court accepts the government's argument that, and I'm reading this out again because it's very interesting or striking, the interest of children in a complete schooling, allowing a successful integration according to local customs and habits, prevails over the wish of parents to have their daughters exempted from mixed swimming classes. So that's the conclusion here. Now, let's zoom a little bit in on this concept of integration that now seems to be prevalent in the court's reasoning and what also the parties before the court are doing. So interestingly, what you see happening is that the court more or less mimics the integration reasoning that was put forward by the government, while it doesn't take into account that there's actually quite an abundant literature on integration, especially in the field of social sciences. So it just doesn't take that into account. It just basically mimics what the government is saying. So what is this really about? And there may be, if you look at this very abundant literature, yes, you will see there are different opinions about what integration would mean and what it takes exactly. But there are certain trends that come forward. And in any event, it's obvious that this idea of integration always concerns population groups that are different from the majority or dominant group in society, and that integration concerns questions of how can you make these other groups fit in society, how can they become part of society. And that also shows that minorities here are used in the broad sense of the word, so not only traditional minorities, but also minorities with a migrant background, and even broader than that. Integration is often also brought in relation to social inclusion, social cohesion, avoiding segregation. So, you think integration is a good thing, right? What can be bad? What can be wrong if you look at it from that perspective? Also clear is that integration covers all aspects of life, so it covers all dimensions of societal life. And so in the literature you have multiple integration dimensions that are identified, two of which are particularly relevant for the discussion here. On the one hand, you have structural integration, which concerns questions of status, access to institutions, equal access to rights, very much. Basically, there are two foundational values of structural integration. That's on the one hand, this idea of equality, the right to equal treatment, prohibition of discrimination, etc. And on the other hand, the idea of participation. Not just political participation, so whether you're represented in parliament or in local government or something like that, but also socio-economic participation. And that then refers to access to employment, access to education, and actually also more broadly, just participating in public life at all. That's also encompassed in participation. So, that is more or less what we're talking about when we're looking at structural integration. Another important one is what is called identificational integration, and that then concerns feeling of belonging. And this, I belong in this society, I'm part of this society. That is that idea that is covered. Now, and this is very important to the discussion here, there are, as I already said, different views. What am I doing here again? All right. different views and ongoing controversies about the meaning and the implication of integration. And as I said, specifically relevant for the discussion here is this question, okay, what with groups with separate identities, with distinctive identities? How does that relate, the maintenance of separate identities, to a successful integration of these groups concerned? Now, there are differences of opinion in this respect, and it also concerns, okay, the question of what can you actually expect from the others when they need to or try to fit in society? Does it only come from them? Is it a one-way process, or is it a two-way process? Is it something that, okay, it's a give and take from both sides? So the minorities, in the broad sense of the word, need to give a little bit, but also the receiving majority society needs to accommodate, to some extent, the needs of the minorities. So this whole question, one-way, two-way, vision of integration. We'll come back to that. And in any event, what you see happening also specifically at the level of the European Union is a trend towards a recognition of integration as a two-way process, so that it should come from both ways. So hold that thought, and we'll get back to that later. So, yes. Then, how does that then relate to this whole idea of citizenship? Now, again, just as in the case of integration, there's a very broad literature on citizenship with a very clear core idea of what citizenship is about. It concerns the relationship between an individual and a political community, a polity. There have been over time several shifts in what are the spatial communities involved, but since the creation of the nation state is pretty much the central reference point here of the citizenship debate. Also here, very many different dimensions are distinguished in relation to citizenship. So on the one hand, you have legal citizenship, and that concerns having the passport, the nationality, having the passport of a particular state. That's just one component of citizenship, the legal citizenship. Next to that, you have substantive citizenship, and that in turn has several subcomponents. On the one hand, access to rights, equal rights, as a very important component. So an effective protection against discrimination, as being very important in terms of substantive citizenship. Participation also, political, socio-economic participation. At least as a citizen, you should have equal opportunities to participate. And ultimately, it's about one's social membership. So again, this idea of belonging. So clearly, and I don't know whether I have it, yes. There are two things that are, to some extent, maybe I should have asked, doesn't this ring a bell? When I talk about equal rights, participation, belonging, have you not just heard that before, right? Exactly. This is more or less what I've been emphasizing in relation to integration as well. And so on the one hand is incredibly important is the centrality of equal access to rights, equal and effective enjoyment of rights. That is one particular angle that gets a lot of attention. But more generally, so that we have this importance of equality also within the concept of integration, but more generally, this whole idea, these different elements that I've identified for substantive citizenship, that's exactly what we've been talking about in relation, what we've identified as relevant for integration as well. So there is a close, parallel, a close link between the two. And so I'm going to go back to these two angles, the angle of equal rights, equal effective rights, and the angle of the integration in a bit when I'm going to reanalyze these two cases. One more thing, of course, as in relation to integration, also in relation to citizenship, substantive citizenship, the same discussion occurs, like what with these separate identities. You have some that say, well, this giving space to separate identities, that's not good for an idea of an inclusive citizenship. Well, they just say it's bad for citizenship in that respect, as an integrative function of citizenship would be undercut. Whereas there are others that say, no, it's just very important to give some scope to these separate identities because that will promote the multicultural citizenship then. And so again, also here you have these different visions of the relationship between maintenance of separate identities and the idea of citizenship. Last point I want to highlight, oops, that's already there, yes. Well, if you take the citizenship angle, you can claim that there's actually a more positive baseline, because if you combine legal citizenship and the promise of equal opportunities to participation, equal rights, with this idea of substantive citizenship, that you could make the argument, well, that would seem to call for measures that basically ensure that legal citizens all have an effective equal opportunity to participate in public life, that they're not being excluded, that they're not being de facto marginalized. But I'll come back to that when I'm going to have a look at that. So this is a bit the theoretical frame that I'm now going to use when reanalyzing these two cases closely. And so I'm going to do that from two angles. That is the angle of the equal rights and the angle of integration. Important point to start with, in both of these cases, the claimants are legal citizens. So the problems they're encountering is purely in terms of substantive citizenship. Now, before I undertake the analysis in terms of these two angles, the equal rights and the integration angle, I want to start with a critical frame of analysis, just to make you aware of particular starting points. Again, starting from the idea of fundamental rights. Fundamental because of their close relationship to human dignity, etc. So yes, fundamental rights are fundamental. What does that mean in terms of how you review possible limitations to their enjoyment? When you have a convention that concerns the effective protection of fundamental rights. So what do you think then, how should you, as a principle, baseline, relate or review just limitations that governments try to impose on these rights? What is your idea in that respect? As you would expect, that these requirements for limitations are duly, seriously reviewed, right? So let's have a closer look at what is then, how that then would work. So, looking at interpretation principles of fundamental rights. In relation to the scope of application of fundamental rights, what do you think that baseline of a fundamental rights convention implies? When you interpret the scope of application of a right, should that be a broad interpretation or a narrow or restricted interpretation? What do you think? Broad, exactly. So the scope of application is interpreted broadly. That's the whole idea of the convention, right? And so limitations, how are they perceived? Are the limitations that are allowed, are they considered as something that should be interpreted broadly or restrictively? So the baseline is fundamental rights, so limitations are interpreted restrictively. That's the baseline, the whole idea of fundamental rights points in that direction. So that seems to call for a rather critical level of scrutiny as a baseline, right? So now what we're going to see happening is, well, very critical remarks that can be made in what happens at the level both of legitimate aim and the proportionality review in both of these cases. Let's return to SAS. Yes, first I'm going to look at freedom of religion and then the prohibition of discrimination. So, the legitimate aim that was proclaimed in SAS. Let's not forget that in principle for Article 9, these legitimate, Article 9, freedom to manifest your religion, the legitimate aims that are enumerated in Article 9 itself are enumerated exhaustively. So you need to be able to, as a state, and when you have a limitation to a right, you need to be able to fit the legitimate aim that you want to evoke under these aims that are enumerated in Article 9. And so there's a certain restriction there. These concepts may be broad, but nevertheless. So in principle, it should be you should stick to these particular legitimate aims. And as I already showed you, in principle, initially the impression that you get is when you look at what the court is doing in relation to the legitimate aim in SAS, it seems to start quite, demanding. It doesn't accept gender equality, it doesn't accept human dignity, so you think, yeah, good, they're serious about what they're doing. And then they accept these minimum requirements of life in French society and living together. I'm like, what? Huh? That is accepted out of the blue in terms of the respect of rights or the protection of rights and freedoms of others. But think about this. Who are these others that we're talking about? So you're limiting the rights of minorities to protect the rights of others. What others? And then you look at what the government is saying. And so the government describes the wearing of a face-covering veil as an expression of the rejection of the majority. So who are the others? The others are the majority. So this is a clear case of majoritarianism. And so what you see happening is that the government opposes the rights of the minority to the rights of the majority, and, importantly, the rights of the majority from the rights of the minority. Now, interestingly, the applicant clearly feels the way this is going, and it says, well, no. This is the government's view of what it takes to live together. This is not the view of the minority. It doesn't take into account our perception of living together. So it clearly highlights the one-sided nature of this endeavor of the French government. Now, the court, sadly enough, follows the argument of the French government. And basically, in that respect, it actually engages in majoritarianism, and it kind of glosses over what I call the counter-majoritarian core of fundamental rights. What is that counter-majoritarian core of fundamental rights? What am I referring to? Well, in this respect, you have to take a quick historical step back. How did it all start, this thinking in terms of fundamental rights? This started, especially, it was triggered to protect minorities that were suffering atrocities by their rulers. So the thinking, and initially these were religious minorities, that's the whole thinking in terms of fundamental rights started with the rights of minorities. The aim was to protect minorities against the pressure of the majority, the government normally representing the majority, the rulers representing the majority. And then later on, these rights became rights for everyone. But it was always emphasized, yes, but we have to make sure that minorities are protected against undue majority pressure. So this idea of the counter-majoritarian core of fundamental rights, that's the way it started, and that's the way it was always perceived. What you see happening in this case is a very worrying reversal of thinking. And this majoritarianism put forward by the government and accepted, sadly enough, by the court. Now, basically what you see happening then we go to the second step. This was a legitimate aim, so now we go to the second step, the proportionality review in terms of the freedom to manifest your religion. And there, we need to reflect on this very important doctrine that the European Court has developed about the margin of appreciation. Remember what we said, the baseline, the critical frame that I was painting, the baseline level of scrutiny of a court should be, of a human rights court, should be a rather elevated level of scrutiny, right? That's what we had agreed on while we were looking at the basic principles. What you see happening is that the European Court grants a certain margin of appreciation to states in relation to this proportionality review, because states would be better placed and they would know better what the requirements were of their society. So the court gives them a little bit of discretion, if you like. Now, importantly is, how broad is the margin? Because I already highlighted, the broader the margin a state gets from the court, the lower the scrutiny, the lighter the scrutiny the court adopts. These are inversely related. So it really matters in terms of effective protection. When you give a broad margin to a state, that means that the court is stepping back. And so there's less protection actually granted. Now, interestingly enough, the court uses this all the time, this margin of depreciation, doctrine, but it has not yet developed actually a clear theory about what are the relevant factors and how that determine the width of the margin and how do they relate to one another. And if you look at academia, they have of course looked at this jurisprudence and they've identified certain factors as being relevant, like the nature of the right, the kind of legitimate aim, and importance for us here, the general policy choices and the lack of European consensus. And so the court seems to grant states always a broad margin when something is qualified as a general policy choice or when the court says that there is no European consensus. Now, interestingly, let's have a look. This was actually a little bit of theory, right? So now we return to SAS. I'm sorry, I'm getting hot here. If you don't mind. And even if you do, I'm going to get rid of it anyway. It's not getting too warm. Anyhow. So what you see happening, remember in SAS, the court had started saying, when it was discussing the legitimate aim, it's a broad notion, so we should have a careful examination and this risk of abuse and the prejudice and blah, 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 stereotypes, etc., etc. So it seemed to say we actually need to scrutinize strictly. So you would expect at the level of the proportionality review that the court would give a narrow margin. But that's not what it does. It gives a broad margin. And how does it do that? It emphasizes the fact that there is no European consensus and that this is a choice of society. So, general policy choice, hands up. Now, the general policy choice, I don't want to go into discussion about that, but I do want to emphasize the fact that this lack of European consensus, what the court invokes to grant a broad margin, that wasn't really the case at that point. The court itself acknowledges that France was actually the only country that had a full ban on the burqa. According to me, that shows that there's a European consensus not to have a full ban. But, so the court kind of then adds, okay, so France may be the only country that has the full ban, but, there are other countries where it's still a question of discussion. Conclusion, there's no European consensus. I just want to give you the feeling, the way the court uses the margin of appreciation, it's not an objective thing. And what you can see is that the court frames the case it has in front of it in such a way that it can give France a broad margin. It obviously doesn't want to scrutinize too closely. We can discuss about why that is later, but this is really the court choosing to step back. Regarding the discrimination claim, we already highlighted the fact that the court chose in that SS case not to have an explicit non-discrimination analysis. And so basically underplaying that the prohibition of discrimination adds a particular dimension at least, if not, this is completely separate right, to the convention, or as a conventional right. Basically, this stepping away, this avoiding of a non-discrimination analysis, what you see happening in SAS, is actually very difficult to reconcile with the fact that the court itself highlights the Islamophobic context in which the law was adopted, and it highlights the risks involved when a court actually when a government does adopt a law of this nature in an Islamophobic context. So the court itself acknowledges and places the case in an Islamophobic context, and it still steps back, it still avoids a non-discrimination analysis. That is really, very counterintuitive, and at least shows that the court itself seems not too worried to contribute to an effective protection against discrimination on grounds of religion. And so that is what I see happening, my interpretation, what I see happening in this particular case. And so the court risks emptying the prohibition of discrimination of any useful content. If even in a case that it considers so Islamophobic, it doesn't engage in it. All right, that was SAS. Let's have a look at this other case, Osmanoglu and Koshabov versus Switzerland. So basically here you have again, you can see the same majoritarianism coming in the reasoning of the court, and even more explicitly. Because what the court is doing is it limits the rights of that particular religious minorities with a migrant background in order to improve societal integration of children, foreign children with a different religious background. But what are we talking? Again, it is in the name of rights, the protection of the rights and the freedoms of others. So again, this question, who are these others here? And so what you... Oh my God, sorry. I had put it on quiet actually a second ago. I don't know what happened. This is just my alarm, so let me... It's mute, I don't know why it comes through. Okay, but it's quiet now. Fine. Apologies, guys. Yes. Where was I? Yeah. So basically, the government invokes this social integration of these foreign children. And in relation to the protection of the rights and freedoms of others, again, the question is, who are these others? But it's clear from the reasoning put forward by the government that it considers this lack of social integration as a risk for society at large in the eyes of what the majority in that society considers to be important. So it's again a perspective where the government opposes the rights of the minority to the rights of the majority, the view that the majority has of what is needed to have an integrated society. So you have again this opposition where the rights or the interests of the majority trump the interests of the minority. So that's, again, this majoritarianism that you see happening. And again here, without much argumentation, broad margin of appreciation given to the state, which further extends that majoritarianism. And so basically, as I highlighted before, the parents had, in relation to this proportionality argument, argued as yes, social integration is important, but we are socially integrated, so this whole thing about the mixed swimming is not necessary. And so that would mean there's no proportionality of the way the government is limiting our rights. And that was basically the argument of the claimants. And so what you see happening, broad margins, so there's a very light scrutiny, and the court basically glosses over the arguments of the parents and their different views of integration. Regarding the discrimination complaint. Now, at first sight, you may think, yeah, but this Osmanoglu case, it's very different from the SAS case. In SAS, you have this law made in an Islamophobic context, and so that had a very particular Islamophobic vibe to it. That wasn't the case here, in the Swiss case. However, if you look closer, it becomes less obvious because when the Swiss Supreme Court was dealing with this particular case, it actually noted that this whole concern for social integration, that was of specific relevance for the Muslim minority because they had grown so exponentially in the last time. So basically already you have again this specific bias, specific concern focused in relation to the Muslim minority. So the Muslim minority was, at least at the level of application, targeted in terms of this measure. The problem being that, again, the court doesn't take that into account in its analysis in relation to this argument of the parents that said, yes, but there is this discriminatory application of the norms. These Orthodox parents and the Jewish Orthodox parents, they get the exemption. There the court said, yeah, but you haven't proven that. And that may be so, but it also at the same time shows how difficult it often is to prove discrimination in a context of what you call deep or systemic discrimination. When a society is structured along the principles of the majority, it may be very difficult to prove a discriminatory element therein. So again, even though there was no specific discrimination complaint, the complaint that was voiced in terms of discrimination was again, stepped over easily by the court. So, what are the problems that we're seeing here in terms of the equal rights analysis? equal rights angle. Basically, what you see happening is that the court enables governments, enables governments to impose the majority way of life under the veil of integration. So basically suppressing minorities' ways of life in favor of the majority way of life. And this goes hand in hand with several retreats, very extensive, very strong previous lines of jurisprudence of the court. And the court has always emphasized that the importance of pluralism and protecting pluralism in a democratic society. I always emphasize that, and this meaning that a minority should be protected against undue majority pressure. And several cases, case after case, where the court emphasized this principle. Then you also have the Chapman case, in which the court even said, states have even a duty to take into account minorities' needs, not only when they make the law, but also when they apply the law. And so these are all concerns that seem to be very protective in principle of minorities' needs, minorities' interests. This reasoning, what you see happening here in these particular cases, is a complete polar opposite of these principles that the court used to emphasize. And basically, as I already hinted at before, what you see happening here is actually almost a reversal of the entire human rights logic. What do I mean with this human rights logic? Human rights logic being, in principle, when a right is there, when a particular something falls within the scope of application of a fundamental right, this basically needs to be protected by states, and they can only limit it if they have damn good reasons, a legitimate aim, proportionality, to limit it. What you see, the reasoning that is developed in these cases here seems to turn it around. It's almost like the minorities only have a right to be respected in their religiously inspired way of life, insofar as the majority wants to, insofar as the majority likes to, accepts it. Right? So this is in that respect a reversal of the human rights logic, and very worrying indeed. And this could also actually explain this majoritarianism that you see happening. It could also explain why the court avoids the non-discrimination analysis, where that would obviously be a major attention point. And so that seems to be what is happening. Quickly, how can you relate that to because I think most of my arguments are already developed in what I said before, but if we now look at this integration angle as a second angle, to look at the two cases and discuss the way the court seems to challenge the boundaries of citizenship from the integration angle, what do you see happening? On the one hand, as I already highlighted, the court chooses to follow a very one-sided view of integration that is being put forward by the government, and glosses over an alternative view of integration put forward by the minority. And that seems to hint to a vision of integration as a one-way process, and so not in line with what is also very much proclaimed by the European Union, that integration should be a two-way process. Secondly, and it was especially visible in the case of Osmanoglu, the swimming case. Basically, the big literature, extensive literature on integration emphasizes that, in the whole integration process, there are very many factors that are at play. And so it is not that the integration, whether or not you're integrated, depends on one particular element. And this is exactly what the government is putting forward in the Osmanoglu case, and what these parents contest, right? That the integration of their children doesn't hinge on whether or not they do this mixed swimming. And it's way more broader, it's a multidimensional process. So that also is not respected by the court here. And similarly, thirdly, the fact that the court avoids a non-discrimination analysis also disregards the central value of the right to equal treatment within or for integration. And then turning to, what does this mean in terms of substantive citizenship? A central point I already highlighted a couple of times. Basically, what the court seems to be doing is that it enables governments to exclude migrant religious minorities from public space at large in SAS, from public education in Osmanoglu, basically marginalizing them. So that is what my claim is, that what is happening in these cases. And in the process also disregards the fundamental value of equal rights, equal opportunities for all legal citizens, and this very core concept, this very core understanding of citizenship. And importantly, there's actually also quite some counterproductive effects taking place here. And so don't forget that the limitations of the rights of these religious minorities are always made in name of integration, or living together, or social integration explicitly. What you see happening, there's already been empirical research has been done about this, that, you know, in the case of SAS with this complete burqa ban, and so the burqa ban was meant to further the living together. But what you see happening is that these women, when they have to choose between, on the one hand, living their lives according with their religion, or going outside and getting lots of fines, is they will choose to stay inside. So instead of participating and living together, these women are staying indoors. So the government doesn't say they have to stay indoors, but when they impose fines on them, if they would go abroad, every single time if they would step out with their burqa, they would be fined. So the result is that they choose to stay inside in order to and respect the law and live in accordance with their religion. So that seems to be the polar opposite of what living together means, is when it means that you're pushing these women in their houses because you basically criminalize them getting out of the house. Similarly, in relation to Osmanoglu, the parents also claimed, because the kids went to a public school, and that was also part of the vision of these parents, that yes, it's important to be integrated. They wanted to send their children to a public school, but they said, well, if we're going to keep getting fines because we don't want our children to participate in mixed swimming, then we're going to pull them out of the public school and put them in a private Muslim school. Bravo for integration and social integration and living together, right? So it's again, you get a counterproductive effect. And I'm not saying that you have to give way to anything minorities want, but it needs to fit into the broader framework, and that is not what is happening here. So by way of conclusion, what I would claim, or what I would suggest that the European Court of Human Rights is doing, is returning to the core of fundamental rights and reversing this majoritarian drive, and so not slipping into this counter-majoritarian, not being tempted to engage in this majoritarianism that the governments put forward, while giving pride of place to the prohibition of discrimination. And this means that when governments fly around with integration arguments, they shouldn't just always wholesale accept that, but remain critical in this respect. And last but not also very importantly, and that might also engage some discussion, this may not always be so straightforward, what I'm saying. Because, of course, then this brings us to the question, why does the court do that? And why does the court step back in relation to controversial questions? Why do you think that is? Why do you think that is, that the court steps back in relation to controversial questions? This is actually to do with the limits of international law to some extent, and the politics that's always behind the law. In the sense that, okay, the court has the power to pronounce legally binding judgments. But if the countries feel, boy, this is completely against our idea of sovereignty, our idea of national constitutional identity, they will say, yeah, damn, we're not going to do that. You're going too far. And so they're going to counter, and it's the idea being that the court is concerned that when they're going to make these judgments in controversial questions, that they will push states to actually threaten the entire system by not respecting the judgments, and thus basically threatening the entire system. So that is why the court thinks, well, it's maybe better that I don't take a position here. And then I think, well, but you always have to keep in mind your core mandate, and your core mandate is to ensure the effective protection of fundamental rights. And yes, there is this concern about the politics involved and trying to keep the states on board, and not that they kind of defect and that everything goes up in shambles. I understand that concern, but I think it's more important to look for a gradual process, or at least not give states carte blanche to do whatever they want, because the whole idea of them becoming party of the European Convention is that they accept that they need to respect that and that the European Court has the final word in principle, right? So to find the midway in that is maybe not immediately push them through their throats that they have to completely change their entire way of doing things, but show them step by step that there are certain limits on the way they are approaching questions of diversity. So that is the way I would like to end my presentation.